For those of you that are new and haven't been to a Ned Talks before, it's just about conversation. So it is very relaxed, and it's all just, we're trying to just share experiences, knowledge, ideas, viewpoints, opinions even. We've got a really good team of people that we've got that are going to be sort of the lead presenters today. So Lynn Marshall, but given the topic, so, capacity or incapacity, Lynn is 37, or actually you said nearly 40 years now as a mental health nurse, and has completed a master's level training in interest assessor for the purpose of undertaking deprivation of liberty and mental health capacity. In short, really experienced for this particular topic. And then I'm very lucky to have Nicola Bushby from Boodle Hatfield. She's part of their private wealth disputes team. And she specialises in trusts and estate litigation, which I know trust is going to be a part of what we're going to talk about today, for high and ultra high net worth individuals and families. She's got a huge amount of experience dealing with complex capacity issues. And then I have Steph, and a few of you I know Steph. Steph is a partner of the private wealth team at Clarion, Leeds-based firm, and she also advises ultra and high net worth clients and their families. But what was particularly interesting, and what the reason I wanted Steph to come on is that I know Clarion, it's a big part for them, but you're all part of the Solicitors for the Elderly Network. So everyone's got a slightly different viewpoint and sort of experience, and so I hope that they can all add different bits. Now, in terms of where this came about and why I thought it was a topic worth talking about, two things. Aging population and dementia is set to triple by 2050, which I know sounds like a really long way away. Well, it does to me. It's 25 years, really, 26 years, and that's not far, and that is a massive increase. And I'm going to steal a phrase from Nicola, in these high net worth families or businesses or whatever it is, when you lose those patriarchs or the people, the matriarchs, whoever's in charge, it creates a vacuum of authority, which obviously will create a huge impact. And it's therefore a bit silly if you're not preparing for the possibility that someone in the driving seat of a family or a business could end up not quite being having their full capacity. So I'm going to stop talking, and I didn't mean to take up that much time, but I would like Lynn to kick it off, because there's a couple of questions that sit firmly in her wheelhouse, and that is, how do you spot when someone may need or may need assessing, and how do you make that assessment? Lynn, over to you.
Morning, everybody. Well, how to spot it? I don't know everybody's background, but I understand that a lot of people are financial advisors, so I assume that maybe you're working with people that you know already, and maybe
it's a sort of split of accountants, legal, and sort of financial services types. That's probably about a fair split, I would say.
Yeah. So I would say if it's people that you already know, then I would say signs of changing personality. Yes, some forgetfulness. Changes in personality, particularly, I would say. A lot of people can spot where someone's memory maybe is going. How to make an assessment? Well, I think it's going to be different for yourselves than it is for me, because I'm a qualified mental capacity assessor. So there is a set criteria I need to use to assess someone, and there is laws that we use as well, because, for example, there's a Mental Capacity Act for most decisions. A lot of decisions I'm making around LPA, applications to court of protection for deputyship, but then when someone's making a will, you're using a different law as well, so your criteria for actually assessing the capacity is going to be different. But the main things I think are around the person's got to understand, retain, weigh up and use, and communicate a decision in terms of Mental Capacity Act. It's decision specific, because what tends to happen sometimes is if someone sees a label of dementia, say someone's had been diagnosed with dementia is an assumption that that means that they can't make decisions for themselves. And it doesn't at all. People are getting diagnosed a lot earlier these days. And they can make decisions for themselves, but it's got to be decision specific, and it's got to be time specific as well. It's not an exact art. So, for example, I could assess someone one day and come up with my view because it's only my professional opinion. And then the following day, someone else might assess them and they might come up with a different opinion, especially if it's quite borderline. And also it's difficult if it fluctuates. And I think another thing worth mentioning as well is that if someone does present as quite confused, it doesn't necessarily mean they've got dementia either, because as you get older, if you get a urinary tract infection or a chest infection, that can often lead to confusion. So people can present as confused. And there's this automatic jump into the conclusion that they've got dementia, which they might not have. It might be that what they need is a course of antibiotics and they're fine afterwards.
And Lynn, when we spoke, one of the things you mentioned is that when you're in that sort of in between that twilight zone, I think was a phrase that actually Nicola used when we spoke, where it's not obvious either way. It sometimes, depending on the time of the day, that they can come across as very coherent or not, and so it is a temporary thing. Is that right?
Well, yes. I mean, people's capacity can fluctuate, and for example, I do not so much with the capacity assessments I'm doing around LPA and wills or court protection applications, but certainly when I'm doing deprivation of liberty assessments, sometimes I've been back 4 times to see people because it isn't clear. And if it's a really important decision that's being made, it might be that it needs to be delayed, because that's the other thing, you can delay a decision. But you might need to see them several times.
And sometimes, Lynn, do you get families or professionals approaching you for assessments where they think the client's making a really silly decision, and that they assume that means the client therefore doesn't have capacity, or the family member doesn't have capacity? But it's quite a renowned principle, isn't it, that you're allowed to make stupid decisions. That doesn't necessarily equate to lacking mental capacity. Sometimes it does, but not always.
No, I've not actually had that. What I have had a lot of is where there's complex family situations, and it's quite likely that the will is going to be contested, the will or LPA is going to be contested, because you come across some very complex family situations. And sometimes it's like it's all out war amongst family members. So when finances particularly are being discussed, that can happen. And it's one of the reasons why a lot of the solicitors want to make sure that particularly when someone's changing a will, is that it's watertight, because there's a potential there for it to be contested.
And I think solicitors are well known for needing to do that now, because we've been burnt so many times, because great litigators like Nicola will come along and say, where's your capacity assessment then, Steph? And, thank God normally we'll have it on the file. But I always worry sometimes that other professionals may not be as alive to needing those capacity assessments on their files as the lawyers are. So I've seen, changes in pension nominations, or changes in things that don't come through the will, or changes in life insurance nominations happening just very flippantly through the post, without necessarily a thorough assessment of the client's capacity to make those massive decisions. I wonder how frequently do you get questions from non-lawyers to assess capacity?
Sometimes they come from family members.
Yeah.
Most of them do come from solicitors. There's been a few from financial advisors as well.
Oh, that's good.
But sometimes it's family members. Especially the other complicated situation is second marriages, I suppose, where somebody's married for a second time and decides to either change their will or change their LPA, which is like igniting a fire for some people. And Lynn, situations can be really difficult.
Yeah, no, I think that feeds into a really nice point that I think Nicola's going to kick off with, or finish with at the end, which is predatory marriages, which I know is a bit of a leap. Doesn't mean a second marriage is a predatory marriage, but it's possibly a nice link there. I'm conscious that we're nearly halfway through, so there's a couple of sort of bits sort of past the assessment, and that's just looking at what are the different ways to manage other people's affairs, and I think that's possibly one for Nicola at this stage, if that's all right, Nicola.
Yeah, sure. So, there's two main routes. So there's the attorneyship route or the deputyship route. If someone has capacity to make a lasting power of attorney, i.e. give somebody else they trust the power to stand in their shoes if they do lose capacity, then they can execute one of those quite easily. It's pretty straightforward process. Obviously, the more complicated your affairs are, it can be slightly more tricky. Always a good idea to consult somebody who knows how to make them. Or if you have already lost capacity, and so the family are kind of left behind thinking, well, what do I do? Dad's lost capacity. He's got all this wealth to manage. Then you would have to apply to the Court of Protection to become or to be appointed a deputy. And then you stand in the shoes of your dad, and you can manage his affairs as if you were him. It confers sort of a general power. So if you're an attorney or a deputy, you have general powers to manage someone's affairs, but there is a limit on that power. They're not limitless. So, for example, gifts is always a bit of a sticking point. There's specific rules about gifting. So you can make small, sort of modest gifts around sort of Christmas, birthdays, but anything substantial. So if you want to make, for example, a lifetime gift, and you've lost capacity to make that gift yourself, then your attorney, deputy, or whoever seeks to make that gift will need to apply to the Court of Protection for authority. So quite often somebody might be in the middle of estate planning, or was doing various things but hasn't got round to sort of gifting that property to their daughter to ensure that it's not sort of doesn't fall within their estate when they die. It doesn't mean just because they've lost capacity that can't still happen, but it does mean that you've got to go through the court process and get the court's authority to make that gift. Attorneys, deputies, they can't make wills on behalf of an incapacitous person. Again, you've got to go to the Court of Protection if you want to get a will for that, for that relative, for example. So there's, as I say, there's limits. But
the limits, Nicola, is that a sort of a hard limit, or is it a percentage of the estate, or what are those? Yeah, what do those limits look like?
Well, for gifts, without sort of going sort of too granular, there's specific rules. It's very small sums that you're entitled to make sort of on an annual basis. Anything above that, as I say, anything remotely substantial will need authority from the Court of Protection.
How easy is it to get these rulings from the Court of Protection?
So for a gift, for example, I think the two things that the court look at when deciding whether to authorise a gift is firstly whether there's a track record of kind of tax planning, estate planning. If you're just sort of rocking up to the court asking for authority to gift dad's property to mitigate IHT, but he's never ever touched estate planning or never done any tax planning in the past, I think that's going to be difficult to persuade the court that actually this is something that dad was concerned about and that he would have done had he had capacity.
And how about just getting the deputyship or the power of attorney once somebody's lost capacity? Is it a nightmare, or is it?
No. Deputyships are generally very straightforward. If you want to be appointed and you apply, unless there's any objection, then that ought to go through quite easily. The only kind of sticking point is probably if there's a very significant estate and you are sort of one lay person the court could say, well, actually, you know, this is a £30 million estate and you have no real sort of experience in managing this kind of money. Maybe you're not suitable. There's a possibility of that. But generally, if you are, say, you know, daughter of dad and you want to look after his money and his affairs as a deputy, and you apply and no one objects to that application, then the likelihood is that the court will just consider it on the papers, no hearing, and will authorise that.
I would probably should just chip in and say, though, that the time that it takes to get a deputyship order at the minute anyway for our team is taking anything up to 12 months. So as professionals, we massively encourage wherever possible to get the LPAs in place, because the cost difference for a deputyship and an LPA, massively different. The ongoing obligations under a deputyship to the court compared to an LPA, massively more onerous. So if you can encourage your clients down the LPA route and they still have capacity, or even with a bit of encouragement from Lynn, we can get them over that line to have capacity, way more beneficial to the family overall. The deputyship route, I always like to think that's the last place you want to be, as sometimes families have to be because maybe the client's never had capacity, but powers of attorney, much more straightforward, quicker, cheaper.
How do families manage in that 12 months when they haven't? That's mind-blowing.
Yeah, you can apply for interim orders. So sometimes we'll apply for an interim order to access a limited amount of cash in the interim, or we'll ask for an interim order to sell a property. But yeah, we've got care homes where, you know, they will have been in care for 6-9 months before anyone's even thought about needing a deputyship for the resident, and there'll be hundreds of thousands outstanding. And unfortunately, that is the length of time with court. And we do a lot of our applications online as well. So we're probably some of the quicker ones. It's very time consuming and costly. You're talking thousands often if you instruct a solicitor to get a deputyship, and with the ongoing administration afterwards and the insurance that you need as a deputy compared to what you don't need as a power of attorney. I think if you can encourage those clients down the power of attorney route, it pays dividends.
I was just going to say that I do a lot of court protection applications for deputyship, where someone's moved into a home mainly, and the care home fees need paying, but the LPA is not in place. But in my experience, I've had quite a few where when I've actually gone out to do the assessment, the person's got capacity to do an LPA. And I find that really frustrating. So now I'm up front saying, just make sure before you go down that route that, you know, you've ruled out the fact that they can actually make an LPA. But there's this assumption, as I say, that just because someone's got dementia and confused, they can't do an LPA. Well, some of them can.
Okay.
But I think just on the LPA front, I think, yes, they are great and they are cheaper and you can do them. And, you know, and what you say, Steph, is sort of underscores the importance of planning things. But you know, just make sure that your clients are donating that power to somebody they really trust, because obviously I'm a litigator, so I pick it up when when that attorney perhaps doesn't behave properly, and they use that power and they, you know, use it for their own financial benefit, and they, you know, they do things, they transfer properties to themselves, they give money to themselves, and there is I think generally compared to a deputyship, less oversight.
100%.
And so, yeah, you need to, the importance of the identity of that attorney is absolutely, you know, the identity of that attorney is absolutely critical.
Who was the judge, Nicola? Was it Denzel Lush who said he would never do a power of attorney because of that exact point? Yeah. And he said he would always prefer the deputyship because there's way more oversight from the court. It was definitely someone.
Yeah. So there's pros and cons of each.
I'll tell you what I'd like to follow up on afterwards is a bullet point to everyone that's on here with the pros and cons for both, just so they've got something they can remember, because I guarantee you, well, I certainly won't remember everything you've said, and that seems like quite a key point. So we are rapidly running out of time. Now, virtually everyone on this call has international clients to one point or another. And then so the next point that I think we were going to go through was, how do you get these powers that you've just gone through recognized in different jurisdictions? And that's either, well, Nicola, Steph, anyone if they want to chip in, but obviously Nicola and Steph are the people leading this perspective.
I mean, just a short point, because we don't have very much time, but I mean, ultimately, the sort of the summary of the position is that there isn't some kind of global power that you can use. So there isn't sort of a worldwide lasting power of attorney that you can just make, and then it sort of governs all of your assets across the globe. That doesn't exist. There's some kind of idea to create that, but I think that's going to be quite a feat, I think, to coordinate all of those different countries. So at the moment, what you're left with is essentially having a power here in England that governs your English and Welsh assets, and then getting that power recognised in the jurisdictions where you have assets. There is kind of a shorter form recognition procedure sometimes in different countries, depending on which country. Otherwise, you're having to start something from scratch in that country to manage that particular asset. You've got a villa in Spain. You need to get something in Spain to manage that villa. In the event that you lose capacity, you have somebody there on standby under this power to look after it for you. And I think you just need to, if you're wealthy and you've got lots of assets worldwide, you really ought to be trying to do that now when you have capacity. And it feels quite expensive and unnecessary, because I think most people just think, oh, I'm not going to lose capacity, it's fine. But I think it is one of those things that, you take care of your physical health, you get kind of, insurance, you get life insurance. It's just one of those extra things. Yes, it's expensive, but can you imagine trying to do that once for your family, once you've lost capacity in all of those different countries? It's a complete nightmare, and it causes problems. Then you've got your family trying to pick up the pieces. So I think, when you do have those sort of worldwide assets, I think the importance of sort of prior planning is even more important.
No,
and we get a lot of clients sometimes saying it will be fine because I own them in joint names with my spouse, and that might be okay with, say, a bank account where the other co-owner might be able to access it if the one party lost capacity, but it wouldn't help with a property ownership. If that property needed to be sold in Spain and it was co-owned with someone who lacked capacity, I don't believe the Spanish authorities would be fine just selling it by the one with capacity. So you'll often hear clients say, well, it's fine, everything's joint over there. If one of us had an accident, the other one's able to do everything. I don't think that's always the case.
Okay, right. I'm going to have to move on to the next topic. So, and I know this is if I look at everyone on board, trusts and trustees. What happens if a trustee loses capacity? What's the process then?
Do you want me to take that? Oh,
yeah.
No, you do it.
Well, I mean, the opening position is obviously trustees need to have capacity to make decisions, to appoint out trust property, and if they don't, if a trustee doesn't have capacity, say appoints out property from the trust, and then it turns out that they didn't have capacity to make that appointment, then obviously everything unravels, and then you come to someone like me as a litigator and try to sort of set that aside and restore the property back into the trust, because the trustee never had the requisite capacity to make that in the first place. So it's very important that those involved in trust are mindful of this issue, because of its potential to be very difficult if it turns out that the trustee didn't have mental capacity. If you have an incapable trustee, you need to obviously replace them with somebody who is capable. I mean, that's usually provided for under the trust deed, or it can be the continuing trustees who make that decision. If the trustee has a beneficial interest in the trust in some shape or form, you will need to apply to the Court of Protection to get, under English law anyway, apply to the Court of Protection to get that trustee replaced with a capable trustee. So so that's something to be mindful of.
Brilliant.
Thank you. That's a real gallop through, but
yeah, well, that's the gallop through is a good description, I think, of today. As Nicola gave me about double the amount of points, and we sort of went through it and went, oh god, how I think we're going to have to chop this. So, so future-proofing a will. How do we avoid needing to go down the litigation route? What's the sort of steps to avoid that? And then Nicola, that's probably one for yourself.
Yeah, sure. Okay, sure. Sorry. So, I mean, number one recommendation, obviously, a contemporaneous capacity assessment. If you've got an elderly testator or a vulnerable testator, one of the easiest attacks on a will is obviously capacity. You know, they didn't have capacity, or otherwise that they were vulnerable, they were unduly influenced into making that will. So the best way to kind of to bolster that will is to get a capacity assessment, which confirms that the person making the will, the testator, had capacity at the time. Because otherwise you're left trying to sort of put together the pieces retrospectively on a sort of post-death dispute. You're then sort of going back, trying to sort of trawl through medical records. There may not be enough information, trying to put together what the capacity picture was. Whereas if you've got a capacity assessment that was sort of made on the day that she signed the will, then you can say, look, I've got a capacity assessment.
And Lynn, do you ever do sort of someone that's clearly absolutely fine, but in that situation that Nicola's talking to, do you ever come in and go, I've just got to do this because you're in a home or because you're 85 and you've amended or whatever it is? Does that form part of what you do on a sort of your working day?
Well, no, it's normally because it's been identified either that they've got a dementia diagnosis, which often with a solicitor will trigger, well, we need, because of the diagnosis, just to be on the safe side, we need this. Or it's the complex family situation where they're anticipating that someone might well challenge because there's a lot of family conflict.
Yeah. Okay. So I'm conscious we've got a minute left, and this is quite frankly probably for me an interesting topic, and that is predatory marriages. And I think there is a consultation paper going through at the moment. Is that right? And it was Nicola that raised this point with me. So I'll probably hand over to you.
Yeah. The Law Commission has just come out, has just issued a supplementary paper to look at the revocation rule. What I mean by this is when you get married, it automatically revokes your previous will. Lots of people don't necessarily know that. I'm not sure how widely known it is, but yeah, if you get married, it revokes your previous will. So what's happening, I think, increasingly, or that's sort of the general thinking, is that sort of elderly, vulnerable people are being targeted. So sort of predatory parties are coming along, procuring a marriage from somebody who is elderly and vulnerable. It's knocking out their previous will, leaving, and unless they make another will, which if they are incapacitous and unlikely, it leaves them to die with an intestate estate, which means that the predatory party, the new spouse, the sort of predatory spouse, then takes the lion's share of the estate, or all of the estate if there's no children or grandchildren. So it's a way. So what the Law Commission is looking at is whether we should get rid of this rule. So if you get married, your will that you've made stays, it doesn't get automatically revoked, because that would be one way of disincentivizing these predatory parties from trying to procure marriages from elderly and vulnerable people. It's complicated because there's other problems that this creates. It's a bit kind of like whack-a-mole. Yes, it solves the issue of the predatory marriage, but then you've got kind of bona fide spouses that are then stuck with an old will that's outdated, and they might not be provided for, and then you've got Inheritance Act claims, and so it's complicated. But this is an issue that seems to be on the rise. It goes to sort of financial abuse more generally, I think, of those who are vulnerable and elderly, and what we can do. And obviously the Court of Protection is has various powers to in relation to sort of stopping marriages and other things to sort of protect these types of vulnerable people.
Yeah, is the vulnerable thing, is there a separation between being vulnerable and not having capacity? Because obviously I'm not experienced in this, but marriage is a contract, and therefore if you don't have capacity, then how can you actually really get married? If does that make, is that, have I
Yeah,
just,
no, you're absolutely right. There is a distinction between lacking capacity and vulnerability. So if you lack capacity, then the Court of Protection certainly has jurisdiction to make declarations about your ability to marry, for example. If you're vulnerable, it does have what's called an inherent jurisdiction. So it's sort of a slightly fluffier sort of power that where they can intervene if it sort of meets threshold, but it's very, very difficult to invoke that. Whereas if it's a more straightforward case of lacking capacity, it's much easier in terms of getting the court involved to do something about it. It's the sort of vulnerability area that's sort of more grey.
Yeah.
But yes, the court can intervene and sort of try and, if you know about the marriage, of course, before it happens. The difficulty is that if you do get married and it does turn out you lacked capacity, it doesn't actually make the marriage void from the start. I mean, it's a big legal kind of issue that I won't bore everyone with. We don't have time anyway for me to bore you.
No, we actually have run over. So by 4 minutes, which I think is probably more than I've ever run over. But it's you know what? And I think I said, this is too big a topic for half an hour, but we're just trying to give it just a flavour. And guys, Lynn, Nicola, Steph, you've done a phenomenal job in covering some massive points in a very short space of time.